Hi, welcome to today's webinar, reviewing Canadian patent law in 2025. So my name is Iris Ngo. I am an associate in the life science group at Smart and Biggar, and I will be moderating today's session. We have three speakers with us here today. Andrea Berenbaum, who is a principal in the life sciences group, Reshika Dhir, who is the practice group lead for the electrical and computer technologies patent group, and Mike Sgro, a senior associate in the life sciences group. So a little bit about Smart and Biggar and who we are. So we are Canada's leading IP firm with expertise in all areas of IP. We have over 180 IP practitioners with a diverse set of backgrounds, and we have 5 offices across Canada. So before we dive into the content, I'd like to start with a few housekeeping notes and details. So our presentation will last about 50 minutes or so, and then will be followed by an open Q&A session where we will address any questions that you have. You're welcome to submit questions at any time during the presentation. You don't have to wait until the end. You can do so by clicking the Q&A panel at the bottom of your screen. We'll try to address as many questions as we can in the Q&A at the end. If you need live captions in French, you can do that by turning on the Show Captions button in the Zoom toolbar, and then selecting translation and French as your caption language. So this webinar is being recorded. You will receive an email with a link to the recording and also a PDF copy of the slides following the session. At the end of the webinar, a survey link will pop up. We would really appreciate it if you could take a few moments to share your feedback on today's session and let us know what other topics you're interested in hearing about in the future. All right, with that out of the way, let's turn to the key topics for today. We'll start with a patent prosecution update for 2025. We'll then talk about the SEC hearing regarding methods of medical treatment and the collection of due care decisions that were released this year. We'll then look at patentable subject matter, claim differentiation, and double patenting. And we'll briefly look at incorporation by references and how that affects novelty, infringement by common design, and lastly, the so-called frozen patent rule. Oops, okay. So up first, we have Reshika, who will give us an update on patent prosecution in 2025.
Hey, thank you, Iris. Let's go to the next slide. Perfect. Okay, well, over the last 18 months, CIPO has been very busy executing one of the most significant modernization efforts in its history, which is the Next Generation Patents Initiative. The ultimate goal is to create a streamlined, centralized, and a fully digital patent ecosystem in Canada. And from a practitioner's perspective, many of the intended outcomes are both welcome and frankly long overdue. These include improvements such as immediate system confirmations. For example, all your filings can now obtain an application number immediately on filing. Similarly, you can receive immediate confirmation of payment as well as real-time confirmation of submission documents. However, as can be expected, the transition from the legacy systems to the new electronic system required CIPO to temporarily pause several core patent office functions around June 2024. And last year, 2025, became the year of gradual resumption of patent processing activities. So some notable services that were resumed in 2025 were, well, CIPO started processing divisional applications. CIPO started sending acknowledgements of examination requests, started publishing applications, as well as start clearing out their notice of allowance backlog. We also saw a resumption of policing of maintenance fee due dates, and CIPO started to issue notices for unpaid maintenance fees. However, unfortunately, we also saw some notices being issued in error, where notices were issued despite payments having been made. And this caused a lot of confusion and panic amongst the professionals as well as the applicants. In December 2025, CIPO started policing late fees and started issuing abandonment notices. And now, according to CIPO's published roadmap, reinstatement process is supposed to resume now, and due care letters and decisions are supposed to start rolling out soon as well. Next slide, please. Thank you. So another big thing that happened last year was the patent term adjustment system ultimately came into force in Canada on January 1st, 2025. And the goal is to account for unreasonable delays by the Canadian Patent Office in issuing a patent. Now, the introduction of the PTA represents a significant sort of policy shift, but the practical impact is expected to be narrow. So some key highlights here are PTA is only available for a patent granting on an application with a filing date on or after December 1st, 2020, and only patents issued on or after December 2nd, 2025, so last month, can be eligible for PTA. Now, a patent may qualify for PTA if CIPO took longer than 5 years after filing or natural phase entry of an application in Canada, or 3 years from the date the examination was requested. So whichever is the later of this date kind of is your target or ideal issue date. And the way the formula works is you would look at the actual issue date of the patent, and that time period between the target issue date and the actual issue date is the maximum PTA term that can arise in any case. However, there are excluded days so there are any delays that are not directly attributable to CIPO need to be deducted from this max PTA term. And there are about 38 instances of these excluded days that are contemplated in the PTA regime, which makes the formula a little complicated. But upon a careful review of this formula, it appears that there's not a whole lot that applicants can do to impact PTA. Essentially, PTA is largely based on how long it takes the patent office to perform 4 key activities. So how long does it take them to issue a first examiner's report or notice of allowance after examination is requested? How long does it take them to issue a second report or notice of allowance after the first response or response to the first office action is filed? How long it takes them to issue a third examiner's report or notice of allowance after the second response is filed, and now how long it takes them to issue the patent after the final fee is paid. On top of sort of the complex calculations of PTA, the other scary thing about this regime is the PTA is not automatic. Anybody who wants to apply for PTA will need to do these calculations on their own, and they have about 3 months from the issuance of the patent to make a request with CIPO for patent term adjustment. And this request needs to be accompanied with an official fee of about $2,500. All right, that's from me. Thank you.
All right. Thanks, Reshika. We'll now turn to Andrea, who will be discussing the Supreme Court of Canada hearing related to methods of medical treatment.
Thank you, Iris. This was one of the big developments in patent law this year. So as an overview, even though the original decision is based on a now repealed section of the Patent Act, methods of medical treatment are generally considered not patentable subject matter in Canada. There are things we as agents can do to get an allowed claim. It's possible to obtain medical use claims. Canada is pretty lenient on this. All 3 major types of use claims are generally considered acceptable. So it's often just possible to convert a method of medical treatment into the corresponding German style or direct style use claim, Swiss style use claim, or EPC 2000, or sometimes called compound or composition for use claim. Next slide, please. However, there's been developing uncertainty in a couple of aspects relating to medical use claims. For example, the position of the Canadian Patent Office is that any use claim that includes method steps or active language is actually a de facto method claim. So if you have a medical use claim that includes active language or steps such as for use in a method or comprising administering or anything active like that, the Canadian Patent Office considers that to be a method of medical treatment. Generally, this is relatively straightforward to rewrite. In some cases, it's more complex. But one of the big issues that's come is dosage ranges, medical use claims that include dosage ranges and regimens. this started to develop in a line of case law in the federal court over 10 years ago, and it's caused a considerable amount of uncertainty in this area. Next slide, please. So it's actually been over 10 years since the Federal Court of Appeal flagged the patentability of methods of medical treatment as being worthy of full consideration by the Supreme Court of Canada. And it has finally come to the court this year. Next slide, please. The sole issue is whether Janssen's Canadian patent relating to paliperidone palmitate is invalid for claiming an unpatentable method of medical treatment. So all of the claims at issue included a dosing regimen for paliperidone palmitate. The Federal Court of Appeal had upheld the finding of the federal court that the claims are not unpatentable methods of medical treatment. They held that the proper inquiry for such claims is whether the use of the invention, so in other words, how to use it, not whether to use it, requires the exercise of skill and judgment. Next slide. So the Supreme Court heard oral arguments on October 9th, 2025, and not surprisingly reserved its decision. In addition to hearing from the parties, the Supreme Court heard submissions from 5 different interveners. I think it's too early for me to make any guesses on the outcome of this case, but I will say that as soon as developments are do come, then we will keep you advised. Thank you.
Great, thank you, Andrea. We'll now move on to Mike, who will discuss the 3 due care court decisions that were released this year.
Thanks, Iris. So the requirement to show due care in limited circumstances to reinstate either an application that's deemed abandoned or a patent deemed expired were introduced in 2019 as part of the amendments to the Act and Rules to implement the Patent Law Treaty. If an application is deemed abandoned or a patent deemed expired for failure to, for example, and most commonly, pay a maintenance fee and late fee timely, then it's necessary for the applicant or patentee to make a request to the commissioner to establish that the failure to timely act occurred in spite of the due care required by these circumstances. In practice, an applicant or patentee will typically have, I'll say, 2 kicks at the can. You file your initial submission. CIPO will then consider the reasons provided, relying on 2 different sections of the Manual of Patent Office Practice, one related to applications, the other to patents, that are largely the same, and taking into account PCT guidance related to restoration of priority. If, after the first submission, CIPO is not satisfied that due care was required or has any questions, they will issue what I will call an intent to refuse letter, providing an additional 30 days for the applicant or patentee to provide additional comments. I will say over the last year, because of the ongoing updates to the IT platform, and probably more so because of the developments in the case law, we have seen some changes in how practice has evolved, and some applicants or patentees have been given additional opportunities to respond based on decisions released in TIFAIR and MATCO, which I will subsequently discuss. Next slide, please, Iris. So the first decision in TIFAIR was actually released in 2024. I guess briefly, for close to 10 years, the maintenance fees had been paid using a system where the Canadian agent would send an email to the patentee asking if the payment should be made. The patentee would confirm, and the payment would, of course, be timely made. In this case, however, the maintenance fee and late fee were not paid. The Canadian agent had, in fact, continued to use the same course of action, sending an email to the patentee. However, all the correspondences related to the maintenance fee and, as necessary, the late fee, ended up being caught by the patentee spam filter. A request was made explaining the situation. The commissioner refused to reverse the deemed expiry, noting that it wasn't clear that there were steps taken to ensure email remained an effective form of communication. the agent didn't appear to have or rely on a backup mechanism to contact the patentee when they didn't receive a reply to any of their numerous emails. And additionally, it wasn't shown, or at least it wasn't argued in the submissions, that the patentee was independently either monitoring or tracking maintenance fee deadlines and whether the fees were being paid. The federal court dismissed an application for judicial review. I think importantly from this decision, the court noted that both the standard applied by the commissioner was not unreasonable, and also confirmed that the guidance relied on by CPOS, this being, for example, MOPOP or the receiving office guidelines, is not limiting. So simply by classifying the error as one that falls into one of the permissible categories does not necessarily mean that a request to reverse the deemed expiry will be successful. In 2025, this case continued. There was an appeal to the Federal Court of Appeal, and that appeal was dismissed. I won't go through this quote in detail, but I think this captures the very contextual nature of these decisions. So here, in contrast to what had happened since 2012, email instructions, and in fact numerous, I think there was 7 or 8, went unanswered. In the context, it was not unreasonable for the commissioner to find that effectively the agent should have followed up here, or that because of the system that was put in place by the patentee, where they wanted to have a final say on whether payments were made, that they would have independently been tracking maintenance fee deadlines and necessary payments. Now, we went, close to 5 years without a single decision, and then we suddenly had a decision from the Federal Court of Appeal and the federal court twice within 2 weeks to start out 2025. And I apologize for anybody who was on this call last year, because you would have seen I actually briefly spoke about these decisions as sort of late breaking news. The second decision of the federal court was the Matco decision. Here, I think we see a situation that is very common in Canadian practice. There are multiple parties who were involved in the payment of a maintenance fee. There was an annuity service, the applicant themselves, a Canadian agent, and US counsel. Prior to the deadline to pay the maintenance fee, the applicant changed annuity services. During a data migration, there was an issue adding 2 of the Canadian applications, one of those being the application at issue. This was flagged to Matco in an email as one of 7 attachments. Matco failed to realize the issue. When the maintenance fee deadline was missed, CPO, of course, issued the commissioner's notice, maintenance fee for an application not paid. The Canadian agent forwarded this to US counsel, but US counsel did not act or forward it to Matco because they had instructions to take no further action with regard to the payment of maintenance fees. So I guess obviously, as this made it to the federal court for judicial review, the request to reverse the deemed abandonment was unsuccessful. The federal court returned the matter to CPO, finding, amongst other things, that the commissioner had erroneously disregarded what happened prior to the initial deadline. This was that data migration error that prevented the relevant application from being added to the active list to be paid, and that the commissioner had improperly focused on actions not taken by US counsel and concluded that no explanation was provided. I think the biggest takeaway that many in the profession had from this was that the court also went on to set out a 2-stage framework that would have required CPO to consider both the original deadline and the late fee deadline, and due care could be shown, or an application should be reinstated if the applicant or patentee could show due care at either point in time. This was a relatively short-lived test. Later in the year, the federal court set aside the decision, or the Federal Court of Appeal, set aside the decision of the federal court, restoring the commissioner's decision. The Federal Court of Appeal highlighted that sending the commissioner's notice to the agent does not create a trap. I won't explain this in detail, but broadly speaking, it had been argued that by sending the commissioner's notice to the agent rather than the applicant, the system is almost setting the applicant or patentee up for failure. Of course, sending a notice to the applicant or patentee would be contrary to established SIPO practice related to correspondence, where there is an agent of record. The court also confirmed that the obligation to exercise due care extends to every party involved, and that I think as importantly as it relates directly to the two-stage test proposed by the federal court, the period of time that is the subject of the due care inquiry is the period of time after the issuance of the commissioner's notice. You're looking at what happened after there was a failure to pay the maintenance fee and the late fee. Regarding the federal court specific reasons, the Court of Appeal found that the court failed to defer to the commissioner's analysis of facts and formed its own conclusion regarding what U.S. counsel knew or should have been instructed to do. This largely comes down to how do you interpret take no further action in respect to the payments of maintenance fees. There's a lot to take in, many decisions in a single year. I think at this point, there's a few key takeaways. One, courts have confirmed the standard that's applied. I have it here on the screen. I won't repeat it. The courts have found it's reasonable for the commissioner to rely on PCG receiving office guidelines related to restoration of priority. And the key period of time, or the period of time you want to look at when assessing whether due care is met, is after the issuance of the commissioner's notice, which of course is after you fail to pay the maintenance fee and the late fee.
Thank you, Mike. So we'll now move back to Reshika, who will discuss patentable subject matter in the context of the Dusom and Canada case.
Thanks, Iris. Okay, so before we get into the case itself, just let's look at the statutory framework that's set out in sections 2 and 27(8) of the Patent Act. Essentially, these sections establish what may and may not qualify as an invention. So section 2 of the Patent Act says that an invention must fall within one of these recognized categories of art, process, machine, manufacture, or composition of matter. And then section 27(8) goes on to talk about what's excluded from this definition of invention, and essentially says that anything that's a mere scientific principle or abstract theorem is not patentable. Anyone with patent prosecution practice also knows to apply SIPO's practice notice 2020, which took into account federal court's decision in the Shafati case. So just a quick recap, in Shafati, federal court said that the problem solution test that was being used at that time for assessing subject matter eligibility in Canada was inconsistent with Canadian law. And then in response to that, we saw SIPO issue a practice notice in 2020, which introduced this concept of actual invention. In the Dusom case, federal court is providing some commentary and criticism of how the commissioner applied the actual invention analysis. And let's look at the next slide quickly. So this is the patent that was the subject of this decision. This patent 028 application is a very old application. It's got a filing date of 2008. It entered national phase in Canada in 2010. And as the title suggests, here, the invention has to do with playing a card game. Next slide, please. Just wanted to put the claim in front of you guys. Obviously, we're not going to look at it in detail, but this is the as filed independent claim 1. The application was filed with about 21 claims that dealt with the method of playing a card game using conventional sort of playing cards. And then there were 3 claims that had a computer implementation of that method of playing a card game. And of course, you look at this claim, it spanned over a couple of pages. It's a very long claim. There's a lot going on here. But it appears that the Patent Office didn't necessarily look at all the elements in this claim, as we'll see, and based on what the court said. So next slide, please. Okay, so this case has a long-running sort of history. As I said, it entered Canada in 2010. Examination was requested in this case in 2013. And then we saw a couple of office actions issued. We saw a final action issued in this case about 5 years from the exam request date. The case ultimately had an appeal board hearing, and ultimately a decision was issued by the commissioner to reject this application. And if you look at the timeline, the decision came in 2024, which was about 16 years from the filing date of this case, of this application, rather. Next slide, please. All right, so appellant basically sought judicial review of the commissioner's decision refusing the application. The commissioner's analysis essentially kind of followed this approach. The commissioner defined the person skilled in the art, in this case, to be team skilled in gaming, poker, and computer programming. Then the commissioner went on to say, well, what would be common general knowledge attributable to this person skilled in the art? And they concluded that would be somebody with the knowledge of standard card game rules. Then the commissioner identified the actual invention of the application and basically concluded that the actual invention was nothing more than rules for a new poker game using conventional playing cards. And similarly, same rules implemented on a conventional computer. Then the commissioner goes on to say that the invention was not an art under Section 2, definition of invention, because it did not alter the character or condition of anything material. Then the commissioner went on to say that the invention also lacked physicality in that the playing cards were standard, and the computer implementation of it did not produce any discernible physical effect. The federal courts ultimately found that the commissioner's decision contained multiple errors of law. Okay, so the first error, according to the court, was a failure to properly construe the claims. So the court says, well, okay, the commissioner identified the person skilled in the art and the common general knowledge, but did not really attempt to construe the claim through their eyes. The court emphasized that the claim construction must consider how a person skilled in the art would read the claims in light of the disclosure, including what problem the inventors are trying to solve and what benefits the invention purported to provide. So essentially saying that the purposive construction to the claims was not actually carried out. And it's also interesting here that the court stated that the commissioner must keep an open eye or open mind to the possibility that a novel business method itself may be an essential element of a valid patent claim. Next slide, please. So the next comment from the court was that the commissioner improperly assessed subject matter patentability by mischaracterizing the actual invention. So essentially the court's saying that because the commissioner did not purposively construe the claims, the third criticism was how the commissioner approached the actual invention analysis. And here, particularly in light of the Federal Court of Appeals decision in previous Benjamin Moore case, became relevant. So this is, I think, one of the sort of key takeaways here is where the court's reiterating that while abstract ideas cannot be saved simply by implementing them on a computer, the court's also kind of warning the examiners to not just hastily conclude that an invention is unpatentable merely because it uses conventional computer technology. The court commented on how the commissioner erred in sort of stripping away all the physical elements of the invention, so all the computer elements and things like that, and leaving only then the new method of playing a known card game as the actual invention. And that sort of rushing into stripping away all the physical activities or physical, elements of a claim is not the correct approach. And then finally, the court found that the commissioner applied an improper definition of patentable art. So here the commissioner basically said that the federal, basically said that the commissioner used the wrong definition of art, the narrower definition of art. And as for Amazon and other cases, the invention need not cause a physical change to be art. Right, and the federal court also emphasized that there is no prohibition per se on patenting subject matter related to card game rules. So as a result, the application was remitted back to the commissioner for re-examination. Next slide, please. And here the court directed the commissioner to purposefully construe the claims and not skip to actual invention analysis, and also caution the commissioner against overstripping on claim features. And the court also said that the commissioner should use the shell oil definition of art and consider whether the invention adds new knowledge that achieves the desired result with commercial value, as opposed to the narrower definition that the commissioner applied. And from a practical standpoint, this decision, I suppose, is another signal that from the federal court that an overly rigid subject matter analysis and application of actual invention test will not be upheld. We really do need purposive construction of claims by the commissioner. And then it also kind of leaves open some hope that perhaps business methods and game mechanics have a place in Canadian patents. All right.
All right, thank you, Reshika. We'll now move on to Andrea for a double header. She'll first talk about claim differentiation and double patenting in the NCS multi-stage and Cobalt case, and then also about double patenting in a patent appeal board decision this year titled Shionogi and Viv Healthcare.
Thanks, Iris. So yes, as Iris said, I'm going to talk about two aspects relating to the NCS and Cobalt appeal. So the facts at issue in this case are that NCS and Cobalt each provide specialized downhole equipment used in something called fracking, which is a method of extracting oil and gas from underground hydrocarbon formations. It's my understanding that in part due to the sheer number of patents that were at issue in this case, this is one of the most complex cases that came before our federal court in terms of patents. And so the Federal Court of Appeal, in part, clarified one aspect of this decision, which related to claim differentiation. The federal court dismissed NCS's actions alleging Cobalt had infringed certain of its patents and allowed Cobalt's counterclaim asserting that NCS had infringed its 571 patent. Next slide. So before I go into more detail about this case, just a brief overview of independent claims versus dependent claims. I feel that most people on this call or watching the webinar would appreciate this, but it really is down to the issue on this appeal. So I just wanted to go over this. Independent claim doesn't refer to any other claim. It's standalone. Dependent claims, they refer to the independent claims, such as this claim 2, it refers to the apparatus of claim 1, and this claim 3, the apparatus of claim 1 or 2. Next slide. So the claims at issue in the 571 patent were claim 6, claim 11, claim 12, and claim 16. Each of these were dependent claims that depended on the claims that preceded them, as shown on this slide. And really, what was at issue here was claim 12, which was asserted, included the feature of an annular barrier. Cobalt acknowledged that the 571 patent covers two distinct embodiments, one where there is a seal and one where there's not a seal. They also alleged infringements of embodiments without a seal. So claim 13, which was not asserted in the case, depends on claim 12 and includes the feature of an annular barrier seal. Next slide. So again, to summarize, claim 12 includes the feature of an annular barrier. It was asserted. Claim 13, not asserted, depends on claim 12 and includes the feature of an annular barrier seal. So in the federal court decision at paragraphs 1041 to 1042, this was a very long decision. They said that NCS argues that because claim 13 is dependent on claim 12, The annular barrier of Claim 12 includes the annular barrier seal, as well as a barrier ring with a gap. So the two different embodiments, one with a seal and one without a seal. This argument is in line with what I think most patent agents in Canada would feel is reasonable. However, the court went on to say that they disagreed. Claim 12 does not include the seal, and NCS's interpretation is a violation of claim differentiation. If Claim 12 contained the seal, Claim 13 would be redundant. Given the presumption against redundancy has not been rebutted here, the limitation in Claim 13 cannot be read into Claim 12. So in the end, because of this, the federal court found the asserted claims were valid and infringed by NCS. However, a lot of people had questions regarding this analysis. Next slide, please. On appeal, NCS argued the federal court erred in concluding the asserted claims do not encompass the seal, and that the error derived from a fundamental misunderstanding of the relationship between independent claims and dependent claims of a patent. The Federal Court of Appeal agreed, holding that the federal court had misapplied the principle of claim differentiation in finding that a limitation of a dependent claim must be excluded from the independent claim. Next slide, please. So the Federal Court of Appeal clarified that the principle of claim differentiation creates a rebuttable presumption that limitations of a dependent claim should not be read into the independent claim, and it therefore functions as a guard against redundancy in the claims of a patent. So in other words, an independent claim encompasses but is not limited to an embodiment of a dependent claim. So the Federal Court of Appeal allowed NCS's appeal of the construction of the claims of the 571 patent. All right, next slide, please. So going on to the second aspect I'm going to talk about in NCS and Cobalt, and also a unique decision of the Patent Appeal Board relating to double patenting, because double patenting does continue to be an issue for Canadian divisional patents and applications. Next slide. Because of its finding that the federal court erred in construing the asserted claims, the Federal Court of Appeal held that the federal court's conclusion that those claims are not invalid for obviousness double patenting must be set aside for redetermination. So what I wanted to highlight here is that in its reasons, the Federal Court of Appeal affirmed that invalidity on the ground of double patenting continues to apply to divisional patents, even though an evergreening wasn't a concern in this case, and also that the test for obviousness double patenting centers on whether the differences between the claims of the first and second patents constitute obvious steps to a person skilled in the art. So this remains a significant issue for applicants and patentees, and I just wanted to quickly go over a Patent Appeal Board decision that issues this year that does show an issue that patentees and applicants in Canada should be alerted to. Next slide. In this commissioner's decision, the Patent Appeal Board considered an application where the claims related to crystal forms of the sodium salt of dolutegravir. So the claims on file were rejected by the examiner in a final action as being obvious over a certain PCT application, which I'm going to call the cited PCT. The Patent Appeal Board brought in a new issue. They further alleged the claims on file were not patentably distinct over what I'm going to refer to as the Canadian National Phase Entry. Next slide. So timeline here, the rejected application was filed on December 8th, 2009, claiming priority to December 11th, 2008. The cited PCT was published on November 2nd, 2006, so it's fully citable as prior art. The cited PCT entered national phase in Canada in 2007, and it issued with 437 claims, including those added after allowance. The amended claims were not citable as prior art regarding the rejected application because they published too late, but they were considered for double patenting. Next slide. In the end, the Patent Appeal Board reversed the decision of the examiner regarding the cited PCT and held that the claims were not obvious. However, the Patent Appeal Board did hold that the claims of the rejected application were not patentably distinct from the claims of the cited national phase entry. So I'm not going to read out the quote in great detail here. The slides will be available afterwards. But I think that this decision highlights that one should be mindful of making amendments during prosecution to an application that narrow the claims to be much, much more specific and much more relevant to a later filed application. Because if those claims were published afterwards, and even though the test for double patenting would apply to them. So that's something that, given our very strict rules regarding double patenting and not having terminal disclaimers or similar mechanisms to overcome objections, people should be mindful of in Canada. Thank you.
Thank you, Andrea. So we'll now give the floor back to Mike, who will talk about the Alexion and Amgen case.
Thank you, Iris. So the test for anticipation, lack of novelty, fairly well established now in Canada. The cited prior art must both disclose and enable the subject matter of a claim to anticipate that claim. If you go back to the Sanofi decision in 2008, the Supreme Court referred to several earlier decisions, one of which stands out and I think has really taken on as sort of the standard statement as to looking at the disclosure requirement for anticipation, that being that you must in effect be able to look at a single publication and find in that publication all the information that is needed to produce the claimed invention. The emphasis on a single publication oftentimes sort of seems to bridge the gap between, are we looking at anticipation or obviousness? If you're mosaicing multiple references, most would argue that is an obvious objection. Although whether there could be a mosaic of references was directly addressed in this decision. So the Alexion decision arises from an infringement action brought in relation to claims 1 and 2 of the 810 patent. This relates to Alexion's eculizumab product, Soliris. Amgen had sought approval of a biosimilar product, Bikemv. For the purposes of the proceedings, Amgen admitted infringement, but alleged that the claims were invalid for either anticipation or obviousness. Spoiler alert, the federal court granted Alexion's declaration of infringement and issued an injunction preventing Amgen from manufacturing, using, or selling Bikemv in Canada until the 810 patent expired. Claim 1 of the patent is an antibody that binds C5 comprising a specifically recited heavy chain and light chain. This is eculizumab. Amgen alleged that the claims, I should mention, claim 2 is a composition claim. So the key is really whether the antibody is novel. Amgen had alleged that the claims were anticipated by a US application or publication, referred to it as US 972. That publication itself doesn't disclose the full sequence of eculizumab, but Amgen argued when example 4 was read together with a reference that was incorporated by reference, it would give the skilled person the sequence of eculizumab. Alexion's argument was that this is not the correct approach to assessing anticipation and is conflating anticipation with obviousness. Perhaps, getting out front of the jurisprudence, this very situation was addressed in the Manual of Patent Office Practice. Now, of course, as noted by the federal court, MOPOP is not binding, and there's actually no jurisprudential reference provided for this position. But the Manual of Patent Office Practice has, since I think the most recent amendment to this section was in 2016, described situations where more than a single document could be considered in assessing a prior disclosure. Next slide, please. Here, the court looked at that section somewhat approvingly, I would say, and confirmed that the idea that anticipation can be met where there's an incorporation by reference is consistent with established principles, noting the critical factor is whether the prior reference provides a clear direction to the person of skill that allows them to arrive inevitably at the claimed invention. clarifying that really there's two types of, I will call incorporation by reference or references to preceding documents that we generally look at when interpreting a prior art document. Those that are seen as just adding new teachings or providing a cumulative effect. You're referring to an example of a specific type of widget. You say such examples are those as described in A, B, C, or D, each of which is incorporated by reference. And I think you would contrast this with another reference, if you're looking at, say, in a specific example, saying this example was carried out using the method of patent A, which really points you to the specific subject matter of the claim and is a more narrow way of incorporating a reference. Next slide, please, Iris. I won't go into the specifics of the technology here. I think that's probably beyond the scope of his presentation, but there's a few points that a few reasons why the court concluded that the incorporation by reference of US 245, which was the reference referred to in example 4, did not amount to an anticipatory reference. Here, effectively, the example was not, if you carried out the example, I should say, you would not inevitably have made eculizumab. Ultimately, to get to the subject matter of the claims, you would have to mosaic different parts from the references and work backwards to create something that was not actually made in the 245 reference itself. Now, the decision could have stopped there. This was not a case where anticipation by incorporation by reference applied. The court did go further and consider anticipation based on Amgen's arguments, but nevertheless, still concluded that even if you took the broader approach where you had taken the entirety of the document or the mosaic of information provided, it still would not have been an anticipatory reference.
Okay, thank you, Mike. So now we're going to go back to Reshika, who will be commenting on an infringement by common design in the Idea Guides and Videotron case.
Thanks, Iris. Okay, so this case is interesting, and from a perspective of patent infringement. I put on the screen a couple of patent applications here. So the first one, the 187 patent filed in 2006, title suggests it's system and method for episode tracking in an interactive media environment. Another patent, 674 from 2001, kind of along the same lines, has to do with media, providing media technology to customers. There are two other patents that were at issue at this case. On the next slide, please. So again, 2005 filing date for one of them and 2006 filing date, but they all basically relate to interactive television program guide technology. Now, this case, let's go to the next slide. So in this case, we have Adea, it's a US company that's suing Videotron, which is a Canadian company incorporated under Quebec laws, over these 4 patents relating to television program guide technology. These patents were licensed to Videotron in the time period of 2010 to 2016, but any subsequent licensing discussions didn't result in a successful licensing deal, and then there was no more sort of licensing deal in place. Now, Adea is suing Videotron for patent infringement, and Videotron counterclaimed asserting invalidity of these patents as well as non-infringement. The key factual wrinkle here is that Videotron did not operate the entire system itself. Instead, it contracted with the US company Comcast to operate the system on its behalf. So Videotron was responsible for managing the content as well as the subscribers, and then Comcast managed the backend platform. Next slide, please. So as can be expected, Videotron argued that because parts of the system were operated by a third party, it could not be liable for infringement. Mind you, Comcast is not a party to this case. Now, the court rejected that argument and applied the common design doctrine. Now, while this doctrine is well established in tort law, as can be seen from the quote on the screen, the court said that this doctrine occasionally got referenced in the context of patent infringement cases, but no case of patent infringement has in fact turned on this issue. But the court goes on to say that a party cannot avoid patent liabilities simply by subcontracting out portions of the infringing activity. And in this case, I mean, this common design doctrine became very relevant because it was concluded that Videotron was in fact infringing 2 of the 4 patents because of the doctrine of common design. This decision is significant in the sense that it potentially expands the scope of sort of infringement liability and cause of action that can be raised in patent infringement cases. It appears that companies should no longer just assume that they're insulated simply because different components of a system are operated by different entities. But of course, this, like any case law, there are very specific facts and evidence that were presented in this case that led to the conclusion and the application of this doctrine successfully. So as more and more cases sort of cite this cause of action in the future, I think this application of this doctrine in the patent litigation infringement regime will become more clear. But nonetheless, it's worth noting that this is an available cause of action. Thank you.
Thanks, Reshika. And last but certainly not least, back to Mike now for a discussion of Biggar and Amgen and the patent register.
The Patent Medicines Notice of Compliance Regulations, PMNOC regulations, mandate the Minister of Health to maintain a register of patents for approved drugs. So this is known as the patent register. So patents that relate to approved drugs can be added to the patent register if the relevant patent lists setting out the patents are timely filed and meet certain criteria set out in the regulations. If a second person seeks to market their own version of a drug or a patented drug and makes reference directly or indirectly to a listed drug with a patent to which there is a listed patent, they're required to address any patents listed on the register at the time of submission. The minister then cannot issue a notice of compliance to a second person, in most cases, generic manufacturer, in many cases, sorry, I should say, the generic manufacturer, until the latest of several dates set out in the regulations. So in the Biggar case, Biggar had sought judicial review of a decision of the minister to list a patent on the register 8 days after it was submitted. It's a relatively interesting set of facts here. The timeline is quite tight. Biggar submitted their relevant patent lists, setting out the 315 patent on August 22nd, 2023. This is the date issued. Within 2 days, Amgen had filed an NDS for a biosimilar product. Now, while Biggar had submitted the lists, the eligibility had not been fully assessed, and the minister did not add the 315 patent to the register until August 30th. The next day, August 31st, is when Amgen's NDS for the biosimilar product was found to be administratively complete. Because the 315 patent was not listed when the NDS was filed, Amgen did not have to address it. Biggar requested that the minister reconsider the listing dates. And of course, since we're here, the minister refused. The federal court concluded that the minister's decision to use the date that the eligibility was determined rather than the submission date was not unreasonable. The regulations permit a first person to submit a patent register, but the minister must consider eligibility before listing. Fundamentally, this comes down to a distinction between submission and eligibility, and taken as a whole, the courts determined that the regulations themselves and supporting guidance suggest that there is a period of time between submission and listing by which the minister has to consider eligibility. And while there may be discretion in determining whether a patent is eligible, which of course leads to the later listing date, there is no discretion to, say, just delay listing once eligibility has been assessed. So the court confirmed, importantly in this case, that the minister doesn't have to add a patent to the register immediately upon submission, and a second person does not have to address a patent that has not been added to the register at the time of their submission. This decision was appealed to the Federal Court of Appeal. Biggar argued several points. So again, the addition should have been considered to have been made on the day of the submission, not the day that eligibility was determined. As a matter of fairness, either the date of the submission or the date of eligibility should be used. And accordingly, if it's the date of submission, then it would seem appropriate to use the date of the new drug submission, in this case for Amgen's product. Or if you're using the eligibility date for listing, then you would use the date that Amgen's submission was considered administratively complete, which was, of course, after the eligibility date, which would have required Amgen to address the patent. Biggar also argued that jurisprudence relied on by the minister and the federal court is distinguishable and unpersuasive in assessing whether the date should be the submission date or the date that eligibility was determined. Ultimately, the Federal Court of Appeal dismissed the appeal, finding that the minister's decision was reasonable. I think this really comes down to, if we look at the fairness argument, if there is an issue with fairness in terms of what date is used, then that was ultimately a decision made in the legislature and reflected in the guidance.
Okay, thank you, Mike. That brings us to the question and answer portion of today's session. We'd be happy to answer any questions that you have. If you have a question, as a reminder, you can submit it at the Q&A panel at the bottom of the screen. So let's begin with our first question. I think this one's more directed towards Reshika, but of course, Mike and Andrea, if you have thoughts, please feel free to jump in. So someone has asked, how does the holding in the ADEA guides case square with the general principle that method claims can only be directly infringed if a single actor performs all the method steps?
Yeah, great question. And I mean, it does, makes you think, because we've got, a situation of divided infringement, which arises when, let's say, there's a patented method with multiple steps that are not all carried out by a single entity, carried out by multiple parties. And the problem in that case is that the patent owner can, sometimes not prove that any one entity is responsible for all the steps, meaning there's no direct infringement. But if the combined actions are clearly infringing the claim and depriving the patent owner of the full enjoyment of their patent, well, this case kind of sort of opens the door slightly in those scenarios, because otherwise you're kind of giving defendants an avenue to escape liability by splitting infringing actions among contractors, partners, and subcontractors. So I think this decision may help address some of the traditional gaps in sort of divided infringement doctrine and things like that. It doesn't entirely erase all the difficulties, especially because, as I said before, this case is very fact-specific, very evidence-intensive, and still developing in courts, frankly. Now, one of the requirements of the infringement by common design appears to be that the two parties should agree on a common action to further a shared goal. And in carrying out that common design or action together, the acts amount to infringement. And so specifically for the ADEA case, it appears that evidence pointing to the fact that there was actual agreement in place or some kind of collaborative plan between Videotron and Comcast kind of helps establish a case that this was sort of, that there is this common design at play here. And I don't know what the decision would be if the facts were different, if it was hard to prove that relationships were informal or loosely defined. And then, mind you, the court's got to also balance sort of opening this door to infringement of common design against any uncertainty or chilling effect that may result if courts start making or performing only one element or few elements of the claimed invention. So it's I think it's more of a wait and watch. Let's see how, as more cases develop in this field, it'd be interesting to see sort of what the scope and the bounds look like. But great question. Thank you.
I see that we're a little bit over time, but I'll just pitch out one more question. So this one's for Mike, but again, Andrea and Reshika, feel free to chime in. So does a submitter of a regular application need to take actions against the patents they list in their submission, or just list them with the expectation that they need to wait until they expire? And this is regarding the PMNOC topic.
Yeah, so I'm going to assume that we're talking about the in this case, the subsequent filer. So if we're talking about a generic, you can wait until expiry, or you can allege, among other things, that the relevant patents are either not infringed or invalid, which is what would have given rise to the Biggar and Amgen cases. There's an allegation of invalidity or non-infringement if it's listed. And so this is what happened in Alexion, actually. You have the validity, you can argue, and then the original NOC holder. So if we're talking about the Alexion case, Alexion then has the opportunity to bring an action for infringement, which then gives rise to the litigation after the fact. But you do not have to wait if you can address it and say that and show that it's either invalid or not infringed. But if the NOC holder, if we're also going to use the term innovator here, challenges that, then there's a 24-month stay that would prevent the Minister of Health from issuing a notice of compliance to the subsequent entry filer while the issues are determined.
Okay, and with that, we've reached the end of our Q&A session. Thank you so much for participating and for your insightful questions. As a note regarding continuing education, this webinar is eligible for both CPD and CLE hours. So that's 1 hour for the LSO and 1 hour for the LSBC and also the Barreau du Québec. So looking ahead, there's a webinar that's focused on reviewing Canadian trademark law in 2025. That's happening tomorrow at the same time, so from 12 to 1 Eastern. If that's of interest to you, I believe that you can still register for it on the Smart and Biggar website. And then as a reminder, when this webinar ends, a survey link will pop up on your screen. And we would greatly appreciate any feedback if you could take a moment to share it with us. All right, thank you again for joining us today, and have a lovely afternoon, and we hope to see you at future sessions.